everybody. Welcome back to the LTL podcast. It is July 28th, 2023. I want to welcome everybody back in to the live chat. Sorry, I was just jamming with my song there when I came in. What's going on, everybody? Hope everybody's doing well. We are back. Another episode of the LTL podcast. Again, like I said, this is episode 44. 44 since relaunching the channel. We're already at episode 44. And, as we know, there has been a lot of interesting documents over the last couple of days in the Brian Kohberger Idaho case. And we're going to go through some of that today, but I'm going to let one of the experts do it. I'm not going to fool anybody. I do not have Peter Tragos on the show. So I want to get that right out there. He actually did a live stream last night and read through the documents. And as you know, I love to go through and play his material here because he is an actual lawyer that can give us some insight as to what's going on. I am not a lawyer. I'm not an expert, but I will say this. It doesn't leave out the possibility of me trying to get him on my show. That is one person that I would love to get over here, as I've been following him for a very long time. If you all don't know, I actually had an interview with Jennifer Coffindaffer the other day. If you missed that interview, I have it actually pinned to the top of this chat. So you can go over there after the show, click on that link and watch this, or put it in your saved queue so you can watch that later. And I would appreciate any comments or thumbs up on that replay because it will help push this out. My goal is to get that interview to 10,000 views on it, and then go from there. But it's got about 4,300 or about 4,300 on it right now. We got some work to do on that video. I want to get it to 10,000. So keep getting over there, pushing that Coffindaffer video. It was an excellent interview. If you have missed it, you missed out on so much. But I'm going to play actually a little bit of a segment from that interview this evening about the possible alibi and the standing silent alibi. And now we've seen this document dump that the defense is asking to dismiss this indictment. And they are quoting law from 1887. That's how we're going to do it. We're going to get through it. You get the law books, you look back in history. We're going to quote some of that law of 1887. That's how we're going to do this. That's how we're going to do it. 1887. Yep. That's how we're going to do this. That's how we're going to get through this. So I think you get my point there. I thought that'd be a little funny little segue. Yes, it is ridiculous. It is ridiculous. And it's crazy. I think I don't want to say it's downright insulting, but I understand what they're doing. It's their job to try to get their client out of jail or dismiss these charges. I'm already going to tell you right now. Let's just say they go into court and judge, look at this. And he says, you know what, there's a significant amount of information here to dismiss the indictment. I'm already going to tell you right now, the state's just going to re-indict. So, as they feel that their case is strong enough, I think this is just going to get dismissed. I think it's just another Hail Mary on the defense. We're going to talk about the alibi, the standing silent alibi. And, what I think essentially what the defense was waiting for was that grand jury testimony. Excuse me, my nose is really itchy, to take a look at it and see if they can start punching some holes in this. I'm actually going to bring up a segment here in a second when I asked Jennifer Coffindaffer about this, and her and I agreed a lot on the same thing, that, you're going to probably get the two witnesses that were in that house that evening, Bethany Funk, Dylan Mortensen. They're probably going to be very fragile inside that courtroom, having to recount everything being on that stand, what happened that night, what were the events leading up to it, what were the events leading after it, do they know Brian Kohberger in any way? You're not going to, they may be fragile, and the defense might push at them and said, are you sure that the person that you saw is 6 foot, 6'3", whatever Kohberger is, because that's been debated about a million times. But let's just say 6'3". And they go, well, I don't know. Maybe he was 5 foot, or maybe he was 5'5". I didn't really look at him. That's what they're looking for. That's what they're going to look for in this alibi, and, use that information to say, well, Your Honor, or, ladies and gentlemen, jury, he could have not have been there. The witness cannot even identify him. The witness didn't even see him in that house. There's a 2-hour gap in between when his phone went off, for the 2 hours and then reconnected as he was going home. Well, we know he's an avid runner. He was out running that night with a friend, or whatever. He was just out on the back roads running. That's essentially what they're going to look to do here. But let's do this. Let's pull up first. I got a article here real quick from Fox News reporting Bryan Kohberger's defense lawyers asked Idaho judge to dismiss indictment. Bryan Kohberger is slated to go on trial later this year for killing of 4 University Idaho students. Attorneys for Bryan Kohberger, the man accused of killing 4 University Idaho students last year, is requesting a judge dismiss the indictment against him. In a Tuesday court filing, lawyers argued that the grand jury was misled as to the standard of proof required for an indictment. They said the Idaho state constitution sets the standard of proof for a grand jury at the beginning, at beyond a reasonable doubt. The filing said that the grand jury was erroneously instructed with the standard of proof required for a presentment, which requires a preliminary hearing. So I think what they're trying to do is the defense wanted that preliminary hearing because it's going to give them the ability to get witnesses on the stand and challenge them. And if they can get that on the record, that's going to create, doubt in when this jury is picked and they start seeing this transcript and reading through it. That's just my opinion. I think that's what they're doing. I think that these are just standard motions in cases that you're going to see, that we probably, will see in cases. So I don't think this is anything groundbreaking, but certainly I know and I understand and respect the filing in the sense of, look, Kohberger is Ann Taylor's client, and she's going to do every single thing to get her client clear of all charges and get him out of jail. So, as far as, is this 1887 thing going to work? I don't think so. I think it's just a bunch of malarkey at this point, and, kind of some grandstanding to try to slow down the process again. So the failure to properly instruct a grand jury as to standard of proof is grounds for dismissal of the indictment. The filing say, let's even say that they dismiss the indictment. The state is just going to re-indict. I'm telling you. It's going to stop the clock, re-indict. It's going to start all this process up again. It's going to continue to get dragged on. If the judge refuses to dismiss the indictment, defense attorney could ask for a preliminary hearing and determine whether their case should move forward. I think that's what they want. It's exactly what they want. They want to get it in front of this preliminary hearing again because they'll be able to get witnesses up there and challenge them. And what do we know? The main 2 witnesses right now are Bethany Funk and Dylan Mortensen. Kohberger's lawyers are filing every possible motion to create an appellate issue. So they're basically getting that on the record. They know that they have a greater chance of getting a death sentence reversed on appeal than convicting a death penalty qualified juror not to return a guilty verdict and death sentence. All right, I'm not going to get too much more into the Fox News article. I just want to give a little bit of a background on what's going on here. I'm sure you're all educated. I'm sure you've been all watching all the live streams. You just come here to hear my take on this today. Just give me about 2 seconds real quick. I just got to do some housekeeping thing here, and then I'm going to pull up that video of Coffindaffer when we talked about the alibi and what her opinion was of it. So let's pull up the conversation I had with Jennifer Coffindaffer. If you haven't seen this video already, again, I have it pinned at the top of the chat. You can go over there and check out that chat after this. But let's play this from mine and Jennifer's interview the other day and just see what she felt about the alibi. Mm-hmm. So we recently just heard about the alibi, or the standing silent alibi. How do you perceive Kohberger's recent alibi and his decision with his team to stand silent once again?
Well, it's interesting. I considered it kind of analogous to a backhanded compliment. This was a backhanded alibi. It wasn't really an alibi. It's basically saying, listen, we're going to use the prosecution's witnesses sort of against their themselves. And they're going to, through testimony and cross-examination, they're going to basically provide some sort of information that it really wasn't Brian Kohberger there. That's kind of what they really, in a nutshell, are trying to say. That combined with experts, right? They're going to have experts on the stand to say, hey, he was actually in Alaska, according to his cell records. Okay, that's a bit out there, but you know what I mean. They're going to say he wasn't in Moscow, Idaho at the pertinent hours when the cell information that law enforcement has gleaned says he was there. They're going to pick apart the videos, even though we've really just seen a handful of the videos and we've seen them in their worst state. We haven't seen them when they've been enhanced for better viewing. But they're still going to have experts to say, no, that's actually, a white Mitsubishi vehicle, or, whatever vehicle they choose. So believe me, they will have experts that will come forward, and this is their plan. But I don't really call it an alibi.
Sure. So, just asking you here, and it's a great segue to what you just actually talked about. So when Ann Taylor speaks about questioning the prosecution's witnesses, whom does she imply, and what does she intend to challenge in those questions during her questioning?
Such a great question. Such a great question. I think the number one person she wants to get up on the stand, as we've seen, is Bethany Funk.
Yeah.
She wants Bethany Funk to say, I didn't hear anything. I didn't see anything. And I can just hear her droning away saying, you mean 4 people were murdered a floor away from you, 2 floors away from you, and you didn't hear anything? Dylan Mortensen heard things. You didn't hear anybody come in.
And this is what I'm sorry to stop the video, but this is what I was talking about, challenging those witnesses, creating doubt in front of the jury.
Didn't hear the dog bark. And so I think she wants to turn Bethany's Funk's possible, admission to, I was asleep and didn't hear anything, turn that around. I think she also can't wait to get her hands on Dylan Mortensen. We'll see how well she holds up. I could tell you, from somebody who's been on the stand for hours and hours and hours as a case agent on different cases, it's grueling. Just imagine if you're sitting there in the hot seat and you have attorneys, 3 attorneys in this case, right? Are they up to 3 or 4 right now? I think there are 4.
4.
Sorry, they just got the DNA expert attorney. 4 attorneys that have spent months, and maybe by that time, years, figuring out questions, forming ideas from 51 terabytes of information, doing whatever they can to discredit Dylan Mortensen, whoever's on the stand. They'll look at a minor case. I'll tell you something I wrote on a tweet accidentally, even though I've talked about ground penetrating radar and known about it for years and years and years, a decade. I put ground penetrating sonar. I don't even know why I put that. It was just kind of a brain fade. So I've got 20 tweets talking about GPR and 1 tweet where I accidentally wrote sonar. And somebody, of course, pointed that out, right? That's what it's like on the stand, only it's happening in real time. And you accidentally say sonar, and they say, see, you didn't, you weren't even there, were you? Because she's right. Say, oh, I also saw eyelashes. Oh, you didn't say that in the probable cause affidavit. You didn't say that in your first statement. So I worry about that young lady. I think she's going to be emotional. She probably has a lot of guilt for surviving, a lot of guilt over actions she did and didn't take. I think they are salivating to get a hold of her and try to turn her words upside down. She's a woman with likely absolutely zero experience testifying. And so those are the two main people I think she's going to focus on.
Yeah, I've been saying here on my podcast and on my shows that I just feel like Ann Taylor's approach, and I call this kind of like the O.J. Simpson approach. I find it funny that I've been hearing this a lot on mainstream media now. I thought that was kind of cute. I heard it actually in a segment today that I was listening to on News Nation. They're actually quoting this now, the O.J. Simpson defense. And I'm like, gee, I've been saying that, and you guys all know I've been saying that for like 3 months on my podcast, and now all the mainstream media channels are using that as a quote. And I'm like, they definitely have watched my show and they're using the shit. Because I've been saying that for a long time. It's hilarious. She's gonna attack the DNA evidence. She's gonna attack the sheath that we know of right now. She's gonna attack the witnesses and their credibility. She's gonna get law enforcement on the stand and challenge their records. How did you collect the evidence? How did you bag the evidence? What was the process? Did you wear boots in the house? Did you have suits on? I feel like they're almost like, I feel like we're going to go right back to O.J. Simpson, and that's going to be the defense here. I mean, am I wrong on that, or do you kind of feel that as well?
I feel that as well. I think it is going to be a lot of mud up against the wall. Let's just see what sticks. We only need one juror, one juror to have some sort of sympathy or doubt, and then it could be a hung jury. So that's what they're hoping for, certainly. I agree with you. I think the good news is, and I know some people aren't going to like me saying this, but I don't think it's going to be televised. It may be streamed, and then later they'll release it how he's done the rest of the hearings or the.
All right, I don't want to get too deep into that, but if you want to go back and watch that, because I want to stay on focus here about getting through these documents. So breaking news last night, we had from News Nation. This was a segment that popped in late last night. Let's play this right here.
Case of Brian Kohberger, the man accused of killing 4 Idaho college students. His lawyers now calling for the grand jury indictment to be thrown out altogether.
1887.
In a just released motion, Kohberger's attorneys say the grand jury was, quote, misled as to the standard of proof required for an indictment. Prosecutors used a grand jury earlier this year to indict Kohberger instead of what's called a preliminary hearing, where a judge would hear evidence and determine if there's enough case to go to trial. Either one is acceptable under Idaho law. But Kohberger's lawyers argue the grand jury should have been instructed that the standard of proof based on what was presented to them is, quote, beyond a reasonable doubt, meaning a very high standard. But they weren't. They say instead they were given a much lower standard. Just, quote,
absurd.
A reasonable ground for believing that a particular individual has committed a certain offense. It makes a huge difference. Now, if true, that would mean the grand jury was told they could indict on a lower standard of proof. Now the defense wants the indictment thrown out or for the judge to order a preliminary hearing.
Thank you, Living Deeply.
This motion comes just days after Kohberger's defense team filed paperwork saying that if the case does go to trial, they intend to present an alibi. It's a requirement in Idaho to inform the court of that. His attorney writing evidence corroborating Mr. Kohberger being at a location other than the King Road address will be disclosed pursuant to discovery and evidentiary rules, as well as statutory requirements. The document stops short of saying where Kohberger was at the time of the killings, because, of course, that's the question we'd all like to know the answer to. Instead, saying that evidence of an alibi, quote, may be offered through cross-examination of state's witnesses and defense experts. He's facing 4 counts of first-degree murder, stabbing deaths of Madison Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin. Convicted, he could face death by firing squad because of a recent change in Idaho state law. Joining us now, Jesse Weber, attorney and host on the Law and Crime Network and a News Nation legal contributor, and Anjanette Levy, correspondent and host for the Law and Crime Network. Both have been following this case closely. All right, Jesse, let's start with this motion to throw out the case. Lay out what is the defense's argument?
Okay, so it's a really interesting argument. They are looking at a statute that's been on the books in Idaho since the beginning.
1887.
And what this statute basically says is a grand jury can only come back with an indictment if they look at all of the evidence and, quote, if it would warrant a conviction by a trial jury. And then they go through a long history lesson about what case law says and what statute says. And they say that language means beyond a reasonable doubt.
Much higher
A
standard.
much higher standard. And they say, listen, if that's the case, and this jury wasn't read the proper standard, it has to be thrown out.
And what do you make of the argument?
It's interesting because what are we in 2023? Why has this not been resolved beforehand? Now, I did a little research.
Yeah.
There were courts that asked this question before, but it never came to a consensus. They cited some of those cases before. The most interesting argument that they put forward is they cited a statute that was put on the books by the Supreme Court, or was interpreted by the Supreme Court. And that statute basically says what you just said before. A grand jury can come back when you find probable cause. Their argument is that's not valid.
Exactly,
you go with the old
Michelle.
statute, and they think that trumps it.
And Jeanette, I'm going to be asking you about the alibi primarily, but anything you want to add on this breaking news of this motion that was just released?
I reviewed it and found many things that Jesse already covered. And the fact that they do cite the Supreme Court saying that all they have to do is find probable cause to indict. But it is an interesting argument. I don't think it's going to fly, though. I just don't think this is going to happen. I think it's clear the defense wanted a preliminary hearing in this case.
Yep.
They wanted to be able to question and cross-examine some of these witnesses before trial.
Yeah. Thank you for watching. Go to
I was trying to get it before
newsnationnow.com.
that. Dang it. Well, we love News Nation. All right, let's get to Banfield. We got Brian Enton late last night chiming in on this. Let's hear what Brian had to say.
Breaking news from Moscow, Idaho. Another document dump in the Idaho student murders case. This one, like so many others, it came as a bit of surprise. A lot of documents tonight. Quite a few. I got to shout out to my friend Anna, who always alerts me, my lawyer friend, when these documents come down and then helps me explain them to me, because this one tonight was quite complex. Brian Kohberger's defense team now asking the judge to throw out Kohberger's indictment that was handed up in May by a grand jury. Kohberger's argument is the grand jury was misled as to the standard of proof needed to bring charges. Here to help us navigate this breaking news tonight, criminal defense attorney Mark Garagos. We couldn't have anyone better on than you, Mark. This is amazing to have you tonight. First of all, what does this mean? Brian Kohberger's defense never wanted a grand jury involved in the first place. Now saying the grand jury process was done all wrong. Do they have a point here?
Yeah, well, yes. I didn't talk to you about it, but I talked to your better half, Ashley. The idea that they went to a grand jury, I think, took the defense by surprise. You'll remember all the skirmishing about one of the witnesses that was out of state that they wanted to have compelled to the preliminary hearing. And they ended up compromising on that and saying they do what was called a deposition in a criminal case, which is not common practice. Here, what they're saying is, look, were not told or given enough advance notice of the fact that they're going to the grand jury, but the standard, meaning the instructions that were read to the grand jury, were wrong. And what do you mean by that? There are jury instructions that tell you what the standard of proof are or is. In a grand jury or a preliminary hearing, that is what's called a probable cause proceeding. That means, I sometimes joke, does that mean my client is breathing? But the legal definition is there a substantial amount of proof of the crime? Obviously there is, and that it ties to the defendant or the accused. Here they're saying that the standard as it was read to the grand jury, and mind you, they've got a court reporter in there that is transcribing everything, and they make the point that the grand jury was misled. Now, that would not necessarily throw out the case. What they're saying is, okay, the grand jury indictment is flawed. Now let's go back and have what we always bargained for, so to speak, which is a preliminary hearing where we get to cross-examine witnesses.
Yep, that's what they want. I've been saying that.
Something you don't get to do in a grand jury indictment.
So we thought there was going to be a preliminary hearing initially. Then there was the secret grand jury, and we found out no preliminary hearing. I mean, do you think there's a good chance we could end up actually having a preliminary hearing after all?
I'm always dubious or cynical about the idea of a judge throwing out a grand jury indictment. It's not commonplace, and especially in a high-profile case like this. But I've seen it happen. I can give you some high-profile examples of when it has happened. I think they do have, the defense has got a compelling point, meaning they said we were led to believe that they were going to do a preliminary hearing. Based on that, we waived our right to a speedy trial, aka preliminary hearing. We relied on it as a contract. Basically, when you waive your right to a speedy preliminary hearing, you're relying on the fact that you're going to get a preliminary hearing. To then have the prosecutor go behind your back, basically, do a secret grand jury indictment, that would mislead. And so if they can show that clearly there's a substantive difference in what the law was that was read to the grand jurors in secret, and they've got the transcript, then a judge has got a real problem. Does he want to go force them to go to trial based on an infirm indictment, or is he better off just giving the defense what they want, or she giving what they want, a preliminary hearing?
What do you make of this defense team, Mark, based on the filings that you've read, from what you've seen? Obviously, you would know way more than me, but just as a non-lawyer, I mean, they seem pretty slick to me with a lot of these filings.
I always resent when somebody calls a defense lawyer slick.
Sorry,
I will tell you,
my dad's
yes.
a defense lawyer, by the way, so take it with love.
I know who your father is, so I don't take it personally.
Okay.
I'm just telling you, I think that this team is very skilled in capital defense. I mean, there are a lot of defense lawyers who are very good, but never do a capital case. Capital cases require a constant.
Thank you for watching. Go to newsnationnow.com to find News Nation on your television provider. And don't forget to click.
Always forget to cut that off. Always forget to cut that off. All right, let's check out Peter Tragos. But before we do, let's march into it like 1887. All right. We had to get our theme music because we're quoting laws from 1887. Oh, boy. This is just getting out of hand here. It's just so out of hand. All right. Let's see what Mr. Handsome himself has to say.
People said I read it. I'm so confused. Hopefully
documents.
I can help with that. We will see. All right. Let's get to it. Let's get right to it.
I'm going to let everybody know I am working on getting Peter on my show. I landed Jennifer the other day. I am definitely working on trying to get Peter on a show. I know he's very, very busy, but I promise I will keep working on it. If I have to send him 1,000 emails a day, I will reach out to him in some point and get him here, even if I can just get him for half an hour. That's my plan. So I'm going to try. That's the guest that I want next on the podcast. I want Peter over here. So I will work on that. I promise you guys. So, all right, let's keep playing through and we'll see what Peter has to say.
Kohberger's motion to dismiss. All right. Buying through his attorney. Here he goes. Motion to dismiss. Issues.
Well, if I get him, then I know he's going to be the most handsome guy on the panel. So maybe I won't get him. I'm just kidding.
Here we go. This is what it's all about. The Idaho Constitution, Article 1, Section 8, set the standard of proof for a grand jury at beyond a reasonable doubt on the plain language of the statute. Is that right? Is that right? Beyond a reasonable doubt for the grand jury? I did not know. I did not think that's what it was. I thought it was like probable cause, more similar to that. All right. The legislative history also supports a beyond a reasonable doubt standard. The Idaho Supreme Court cannot adjust the standard of proof as it is a substantive right. The failure to properly instruct a grand jury as to the standard of proof is grounds for dismissal of the indictment. The grand jury was erroneously instructed with the standard required for a presentment. Thus, this court could treat the indictment as a presentment. All right. Color me confused at the start, people. Color me confused. I will say, if they failed to properly instruct the grand jury as to the standard of proof, that would absolutely be grounds for a dismissal. But just off the issues, which is just kind of like a quick summary type of deal, it sounds like they're saying their argument is the burden of proof is beyond a reasonable doubt for the grand jury, which we'll see. We'll see. But I think that's what they're getting at. They're saying they should have said it was beyond a reasonable doubt. They didn't. Therefore, you have to throw out this indictment. My guess is when we get to the end of this document, I will be surprised if they make an argument where I'm saying, yep, the burden of proof is beyond a reasonable doubt for a grand jury.
He said that even when I was watching this live last night. He's like, I am confused. He says it. Like, what the hell, man?
But let's read the argument together. The Idaho Constitution set the standard of proof for a grand jury at beyond a reasonable doubt. The grand jury ought to find an indictment when all evidence before them, taken together, if unexplained or uncontradicted, would, in their judgment, warrant a conviction by a trial jury. Okay, we're half a page in here. We're half a page in here, and I'm already pausing a lot to think. Okay, I'm pausing a lot to think because this is a new one for me. They're saying the Idaho Constitution says the standard of proof is beyond a reasonable doubt. And then we read the section that they cite, and it doesn't say the standard of proof is beyond a reasonable doubt. I think what they're trying to say is, if the evidence before them taken together, if unexplained and uncontradicted, would warrant a conviction by a trial jury, and to get a conviction by a trial jury, you need proof beyond a reasonable doubt. I think that's the argument they're trying to make. I think they are wrong. Of course, I could be wrong, right? Not in Idaho. This is a new one on me. But let's keep going. The statute was in existence at the time the Idaho Constitution was adopted. When construing the Idaho Constitution, the primary object is to determine the intent of the framers. Provisions of the Idaho Constitution must be construed in light of the law prior to their adoption. Even Idaho's Constitution reflects this view. All laws now in force in the territory of Idaho, which are not repugnant to this Constitution, shall remain in force. In Clark, our Supreme Court found a statute in force at the time our Constitution was ratified to be controlling in its interpretation of Article 1, Section 17. In State v. Matthews, our court considered the issue of whether such search warrants needed to be signed in order to be valid. The court found that warrants do need to be signed, or else a search pursuant to such a warrant will violate Article 1, Section 17 of our Constitution. The court arrived at this conclusion despite the fact that Article 1, Section 17 is completely silent regarding whether a warrant needs a signature. The reason the court was able to find a constitutional violation in this case was by acknowledging that the statutes which require a signature predate the Constitution of the state of Idaho. Because these statutes which require a signature on warrants predated the Idaho Constitution, they create a substantive right which existed prior to the adoption of this state's Constitution. So basically the argument is, if something predates the Constitution, then it is a substantive right. Okay? Haven't heard beyond a reasonable doubt yet. Our Supreme Court found a defendant was entitled to a constitutional relief for a violation, a knock and announce, after finding the rights contained in the statute were long-standing at common law and deeply rooted in our heritage. The Roush Court was able to trace this deeply rooted heritage all the way back to 1603. Oh boy. Oh boy. when we start citing case law from 1603, that's not usually great. That's not usually great. Thus, whatever this language means, it must color this court's interpretation of Article 1, Section 8. The section states, no person shall be held to answer for any felony or criminal offense of any grade unless on presentment or indictment of a grand jury or on information of the public prosecutor after a commitment by a magistrate, except in cases of impeachment, in cases cognizable by probate courts or by justice of the peace, and in cases arising in the militia when in actual service in time of war or public danger, provided that a grand jury may be summoned upon the order of the district court in the manner provided by law, and provided further that after a charge has been ignored by a grand jury, no person shall be held to answer or for trial therefore upon information of public prosecutor. So it seems like indictment or preliminary hearing, but they also have something called a presentment, which is going to come up later, I assume. If it were not clear from the text, the framers' general intent behind the section was to ensure that either a grand jury or a magistrate stood between the prosecutor and the accused. True. Thus, it stands to reason that the standard of proof in effect at the time of the adoption of the section was incorporated into it. It would be rather ineffective to create a buffer between the government and the citizens that the government could change willy-nilly. Willy-nilly. However, that does not provide much information as to what standard would warrant a conviction by a trial jury actually means. I get what they're trying to get at here. To get a conviction from a trial jury, it would need to be beyond a reasonable doubt. Okay? The interpretation of the statute must begin with the literal words of the statute. Those words must be given their plain, usual, and ordinary meaning, and the statute must be construed as a whole. If the statute is not ambiguous, this court does not construe it, but simply follows the law as written. We have consistently held that where statutory language is unambiguous, legislative history and other extrinsic evidence should not be consulted for the purpose of altering the clearly expressed intent of the legislature. The plain text of IC whatever sets the standard of proof that would warrant a conviction at trial. The justification for a conviction at trial is and was proof beyond a reasonable doubt. Okay. So that is what they're going for. That's kind of the definition they came up with. The fact that they even say we got to figure out what this means, yet then they say that it's unambiguous because the court and the judicial branch interprets the law. They don't write the law, but it's also throughout statutes, laws, constitutions across the country that beyond a reasonable doubt is only when life, liberty, and the pursuit of happiness basically is at stake. And that's in criminal cases, not civil cases. And a grand jury indictment does not mean somebody is convicted of the crime. You could be indicted by a grand jury and theoretically get bail and go home and still be living in society and still have your job and still have no issues. Yep. You're just waiting for trial. That's the point of the high standard of beyond a reasonable doubt. I'm just, by the way, it's 11 o'clock at night. We're hanging out, just spitballing here, just spitballing because it's the first time I'm reading this, first time going through this. So I'm just thinking through my head where we get these burdens of proof, why we have them. And I would never think beyond a reasonable doubt is the burden of proof. Not that I'd be opposed to that. It's just a prosecutor. It's a one-sided trial. They should have to prove it beyond a reasonable doubt. Sweet tea for an iced coffee tomorrow. Thank you for this late live. I'm going to need it, sweet tea. I don't like sweet tea, but if I did, I'd buy one because of your name. Net woman. Did Daryl Brooks join the defense team? Glad you still have a voice, Peter. Yeah, I do feel like it's kind of starting to go. But the only live I'm doing tomorrow is the 250K celebration. So that'll be fun. Azam, thank you for the super sticker. Yeah, my voice goes too when I play pickleball with my buddies. I actually see Jeff in the chat, and we're not going to respond because he's telling half truths. Jeff is one of the guys I played pickleball with tonight. Doris, hey, Peter, I'm so glad to catch your podcast. Really makes my day. You cover everything I follow. Thanks so much. Have a blessed day. Thank you so much, Doris. Jeff throwing out numbers that don't make sense. All I know is only one team won 11-1.
That's a lot of feet.
And that was me and
A lot
Lucas,
of
who all of
feet,
you may remember
Amy
from
Lou.
the pickleball video. Hit that like button for me. 2,500 here in the chat. Let's get to 2,000 likes.
Oh, we just
All right.
touched our ears at the same time.
So let's keep
That was
going.
weird. Wow. Did you see that?
If that were not enough, well, sir, I don't think that's enough. Section 191107 is one of the many laws that were adopted in 1863 and 64, copied verbatim from laws adopted in 1851 in the state of California. The Idaho Supreme Court has held, this court has consistently held that a statute which is adopted from another jurisdiction will be presumed to be adopted with the prior construction placed upon it by the courts of such other jurisdiction. This is making me interested to go across and see if anybody has this as a standard of proof in their grand jury process or preliminary hearings or things like that. I don't know. All right. The defendants were indicted for murder in all these cases and arrested. They applied for bail but were denied. On a habeas petition challenging the denial of bail, the California court took time to discuss the legal standard required for finding an indictment. Okay, here we go. Formerly, an indictment was regarded as a mere accusation, which the grand jury ought to find if probable evidence were adduced in support. By great authorities, says Chitty, have taken a more merciful view of the subject, and considering the ignominy. This is going to be brutal. They're talking about 1826. These cases are from 1862. Oh, this is not going to be fun. The dangers of perjury, the anxiety of delay, the misery of a prison, have argued that the grand inquest ought, as far as the evidence before them goes, to be convinced of the guilt of the defendant. Yes. What was therefore anciently said respecting petit treason may be applied to all other offenses, that since it is preferred in the absence of the prisoner, it ought to be supported by substantial testimonies. The more merciful view of the subject, I don't know why I keep saying suspect, thus referred to, is secured by statute in the state. Our Criminal Practice Act declares that the grand jury shall receive none but legal evidence and the best evidence in degree, to the exclusion of hearsay or secondary evidence. And though not bound to hear evidence for the defendant, that it is their duty to weigh all the evidence submitted to them, and when they have reason to believe that other evidence within their reach will explain away the charge, they should order such evidence to be produced, like an alibi or Brady evidence, exculpatory evidence, and that they ought to find an indictment when all the unexplained or uncontradicted evidence warrant a conviction by the trial jury. And of course, ought not to find an indictment when the evidence taken together, if unexplained or uncontradicted, would not warrant such a conviction. The indictment is then something more than a mere accusation based upon probable cause. It is an accusation based upon legal testimony of a direct and positive character, and is the concurring judgment of at least 12 of the grand jurors selected to inquire into all of the public offenses committed or triable within their county, that upon the evidence presented to them, the defendant is guilty. So what's interesting about this is it needs to be something more than a mere accusation based on probable cause. Clear and convincing evidence is more than probable cause. There are standards that are above probable cause that are not beyond a reasonable doubt. Thus, the only case on point from the time this statute was adopted clearly states that the standard for finding an indictment is higher than the probable cause standard. I agree, if that's really how we're going to do this, taking a case from 1826. In addition, other jurisdictions and legal treatises have recognized that the plain language amounts to more than probable cause. The defendant does not, by all this, intend to bury the lead, but merely show that under the usual approach to statutory interpretation, there is no reasonable doubt as to what a grand jury should be instructed. That said, the defense recognizes that the whole of modern jurisprudence on this issue is against it, as well as at least one founding father of this state. Okay, so maybe I'm not crazy. Maybe I'm standing with the whole of modern jurisprudence as I stand against the defense on this issue. I mean, we probably could stop reading there. We're only on page 6. I'll continue on, but it seems like the defense realizes and admits this probably isn't going to happen for them. Crime Sleuthin, thanks for always providing cogent explanations. Appreciate you. Kendall Pittman, best lawyer on YouTube. Thanks for all you do. Thank you, Kendall. And thank you, Denna. All right, the legislative history also supports a beyond a reasonable doubt standard. Here we go. The history of this formulation shows that the abandonment of the standard at the retreat to common law probable cause has no basis in law. To begin, the formulation first appears in 1850 in the Code of Criminal Procedure of the State of New York. Okay, so we have 17 more pages, and I think they're about to go through.
Y'all trolls are funny. You come in here and you put tests to make sure your little chat is going to work. And then you come in here and you put up all this crap in here. It's hilarious. The moderators will take care of you. I love it. Test. They go test. They put these little tests and then they erase them. It's hilarious.
The
I'm good,
legislative
Cal. How are you?
history
Test.
dating back to 1850
Test.
and use that to go against the whole of modern jurisprudence.
Like, so I want to make sure they can chat that the minute
All right.
is up.
The Idaho Supreme Court and the United States Supreme Court have acknowledged that this state has retained the language from the Field Code and its procedural statutes. To understand why the Field Code broke with common law, it helps to have some knowledge of the history of grand juries and the considerable concern about them occurring in the latter half of the 19th century. In England, you never want to bring it back to England. I'm sorry if I'm being too snarky as we read this, but this is not good. This is not good. One man's opinion. All right, what did they do in England? In circa 1978, began with a group of 12 that went on to evolve into a grand jury. The grand jury considered from a historical, political, and legal standpoint. The alternative arrived with a Norman conquest, in which the accuser could raise the hue and cry, and if successful, force the accused to choose between a guilty plea or a trial by combat. All right, English history. I'm going to skim through some of this. Sorry if that annoys anybody. At the time of this country's founding, colonists had at least we got to America now, had knowledge of this history and experience with the power of the grand jury to prevent government abuses. More importantly, the colonies had experience.
Can't hear the music? I was playing the 1887 music. You hear it? We're going to go back to them laws in 1887.
Experience with something that never took hold in England, a
That's
local
so loud
public
here.
or local public prosecutors. While the development of
I know how I can do it. I'll do this. I got it. I know how I can do it. Haha.
magistrate's power to dismiss felonies after preliminary hearing in England is mostly lost. In America, a number of historical writings shed light on what was known to those that adopted the Constitution. There are, however, a few known exceptions to the English procedure. In Massachusetts, the examination procedures seem to have permitted witnesses to be questioned in the presence of the accused. The early New Haven colony departed further from the English model than most colonies. Here, the justice, or more often, the justices, were formally permitted to dismiss charges when they became convinced of an accused innocence. The Virginia county courts initially appeared to have examined arrest suspects to determine whether the accused should be tried before a general court. 1705, are we going backwards? The new institution, the examining court, was introduced after a preliminary hearing before a justice of the peace. The case was sent to a special examining court where the accused was again questioned by several justices of the peace. Here, the accused is entitled to require the sheriff to summon witnesses on his behalf. Either the accused was released or the case went to the grand jury and eventually to a trial jury.
He's even shaking his head.
In spite of their experience with the discretion of the public prosecutor and the protections afforded by a preliminary hearing, it was the grand jury that the colonists looked to for protection from government abuse. Okay, and this is just more about how the founding fathers felt like a grand jury was so important to protect us from the government. Okay. All is not well with grand juries by 1850. People strongly argued the entire jury system should be abolished. American jurists and lawyers were becoming all too aware that grand juries would indict whatever they were told or wanted to indict. Thus, it is unsurprising that the Field Commission wrote in their code, in approaching the subject of the powers and duties of the grand jury, the commissioners have felt much embarrassment and have therefore devoted to it the patient and laborious consideration which is demanded. The value of this institution is at the present day variously regarded. By some, it is deemed of the highest importance as furnishing, by reason of its secrecy, a most valuable aid in the efficient detection of punishment of a crime, while by others, it has been regarded by reason of that very secrecy as submersive of the rights and destructive of the liberty of the citizen. Amy D said late night class with Peter. Yeah, this does feel like late night class. Navas, does this change your perspective of guilt? No, he's presumed innocent. As we sit here right now, he's innocent.
Yeah, he's
I don't think he's going to win this motion to dismiss. He may
Right.
very well lose the trial. I'm not saying he's going to win the trial. I'm not saying he's going to lose the trial. This does not affect my opinion of the trial at all. We're just talking whether or not we think he's going to get this grand jury indictment dismissed. I don't think so.
No,
Maybe the court's going to buy this argument.
Nah.
40 Daughtry. This sounds vaguely sob sit. Not quite, but it sounds like they're trying to take us back. Did Chat GPT write this? Makes sense, right? Because they stop at a certain date, right? I don't think it's quite 1850.
That's pretty
Do you
good.
think they're just reaching at this point?
Yes.
The one thing I guess I could draw from this is maybe they looked through the grand jury proceedings and they couldn't find anything else. That's the one thing I guess we can draw from this. Welcome to all the new members, including Arthur. Pat Bosch, let's read the phone book next. I'm trying not to bore you, but I agree with you. Some of this is tough, so we'll skip some of the boring stuff.
It's really good. Let's get our music going.
All right. With this background, it's easy to see why the Field Commission chose to implement new rules for the grand jury. The authors decided that a grand jury should not admit hearsay, that it should be required to look into exculpatory evidence if it comes across any in its investigation, that its decisions should be challengeable, and as a concluding rule on this subject, a grand jury should be distinctly
I'll
informed
probably get
by the
yelled at
law
on the
that
playback.
they ought to find the
Playing
indictment when all the evidence taken
music.
together warrant a conviction by a trial jury. You have that memorized by now. The attempt to save the grand jury was adopted by California. In 1862, California Supreme Court recognized the importance of the language. Supreme Court likely incorrectly ruled that the grand jury requirements in the Fifth Amendment did not apply to the states, evidently convinced that the common law way of running grand juries was not worth preserving. In 1889, founders of our Constitution got into an agreement,
Yeah,
an
probably get
argument
nailed
about the
in a
necessity of a
Fife
grand
song
jury.
from 1887.
It is somewhat evident they're proceeding in debates, is what they're citing here. It is somewhat evident from the debate that not all parties were fully aware of the controlling law on the issues. One member apparently not aware of who Hurtado had been decided. More to the point, William Claggett of Shoshone County told the assembly that all the grand jury is entitled to do to say there is probable cause to believe the man is guilty. While it is true that Mr. Claggett was an accomplished criminal defense attorney, it seems clear that he had little experience with the field code. Luckily, we're all getting experience tonight with the field code. His statements to the assembly show he did not know a presentment from an information. This should be somewhat unsurprising.
Excuse me.
As California was the first state to adopt the field code, largely because Dudley Field, father of the code's brother, was in the California legislature and later was the fifth justice named to the Supreme Court. History lesson. Perhaps also unsurprising, Justice Field authored People v. Tinder and Smith, which again they've cited here. Regardless of whether Claggett was aware of the laws of the state he was founding in 1889, the practice of prosecution in the aftermath showed what is clear from the statutory language. The standard for the grand jury is beyond a reasonable doubt. Here's what I hate. Don't tell me something is clear. Don't tell me something is clear when it is clearly not clear. Okay? I really don't like when people tell me that something is clear when it's not clear. Maybe I'm slow, and sometimes that happens, especially when it's late. Diana, my attorney and I talk about this case all the time. We both have gut feelings that he's innocent. Thank you for breaking this case down. I work at a criminal law office, and this case still confuses the heck out of me. Thank you, Diana, for the comment. I don't have any gut feelings that he's innocent or anything like that. I would just say that this case should be held to a standard, needs to be proven beyond a reasonable doubt. They need to cross all their T's, dot all their I's, get all their ducks in a row, do it within 6 months. Let's get this trial done in a speedy trial period. If that's what he's demanding, that's where I feel. That's really the only gut feeling I have about this case. Will the state's response, or wait till the state's response sent from my iPad? We are probably not doing anything else tonight besides this. And cool name and picture there, Papa Roger. Sportsy Girl. Thank you so much, Peter. Been waiting, hoping you'd cover this tonight. Please tell me you'll translate to layman's terms. This is making my head spin. Gotta be honest. Old English is not my forte. It seems a little bit like that's where we are going. So let's continue on. It appears the first Idaho case to mention this was Gasper. In Gasper, a defendant was indicted by a grand jury. The defendant filed various motions to set aside the indictment. The court found that the defendant failed to raise any valid challenges to the indictment. After concluding that the defendant failed to raise any valid challenges, the court quoted an intrusion that the grand jury should not find an indictment unless you are satisfied beyond a reasonable doubt from the evidence.
Oh, by the way, let me stop this really quick. Tomorrow night, Tanya and I have something planned. A great Saturday night for all of you. We're going to go over on her show, I think at 7:30. We're going to do a panel over there. And then we're going to come over to my show right after. We're going to drop the link and get everybody to come over. And we're going to do an Idaho show on my channel after. And we're going to take live callers. So it's going to be 2-for-1, double combo meal deal tomorrow. Tanya's got an amazing show lined up. I'll get something together when I get out of work tomorrow at 2. But I do plan on doing live calls. And I don't know, maybe just Tanya get on and we'll just shoot the shit tomorrow. And talk about the recent developments in the case. So it's going to be a really great Saturday night hanging out with all of you. All right, let's get through Peter here, about another 30 minutes or so, and then we'll wrap this puppy up with a big bow on it.
From the government presents that the defendant is guilty. It's back in 1953. We're getting closer to modern times. The court then said in dicta that the instruction is more favorable to one accused before a grand jury than it would be a charge embodying the statute. The court then quoted and again said in dicta, the charge as given calls for a greater degree of proof to justify an indictment than the statute requires. No further analysis is provided by the court as to why the two standards would be different, nor does the court even attempt to identify what the proper standard would be. Okay. The next Idaho case to mention this distinction, in Bullis, a defendant was charged via grand jury indictment. The defendant alleged that the grand jury had received hearsay evidence in violation of 1911-05. However, the court disposed of this argument because appellant has presented no record on appeal of what evidence was before the grand jury. Despite disposing of this argument, the court then made the following comment in dicta. Idaho Code Section 1911-02 only requires that the grand jury find that there is reasonable ground for believing that a particular individual named or described in the presentment has committed a certain public offense. And that's the problem. I mean, anybody who's tried a case knows that you do your best to explain what the burden of proof means, but it is very difficult. Like if I explained it to you and then had you explain it back to me, the difference between greater weight of the evidence, clear and convincing, beyond a reasonable doubt, probable cause, any of those burdens, I think it's very difficult to differentiate between them. I think if you're on a jury, you want to feel like you know that your verdict is right. That's what you want to know. And what that means in your gut, like most of my cases are civil, so it's greater weight of the evidence. Most of the cases I used to try were criminal. So I would say the highest burden in any court, in any judicial system across our country is beyond a reasonable doubt. And now what I try to say is I try to just make that burden seem so low. The greater weight of the evidence, more likely true than not true. You can believe a lot of what the other side says, just as long as we're a little bit ahead of them. Just a little bit ahead of them, we win. You don't have to be positive. And it's really hard for people. It's really hard for people to differentiate between those things. And I'd be willing to bet if this did get dismissed and there's a new law in the land of Idaho that by the way, this could create some serious precedent and other issues in other cases, right? But if they created this and now it's beyond a reasonable doubt, I would be willing to bet it would not change the example. I'm sorry, it would not change the outcome I'm reading the chat at the same time. It would not change the outcome. I think you go before a grand jury, you tell them actually the burden of proof here is beyond a reasonable doubt. Let me explain this case to you. No defense here, no defendant. They're still going to convict or indict. That would be my bet.
Oh, thank you, Jennifer.
Angel D, won't this kind of annoy the judge? No, I don't think it's going to annoy the judge. I think he's going to read it. He's going to consider, he's going to think, listen, new arguments are made all the time. Sometimes they win. Most of the time they don't. Most of the time judges don't want to be the ones to make some new law, but sometimes they win. Does BK have a choice between jury and judge? He has demanded a jury trial, I believe, at this point. In order to go before a judge in most jurisdictions, both sides have to agree. If either side demands a jury trial, you go to trial by jury, usually. Crime sleuthin'. The Lady Anne doth protest too much, methinks. Chase, I moved to the final round of jury selection for a murder trial today, really hoping I survive for hire. Any advice? No, Chase. No advice. I do not want to talk to you about it. Do not talk to me about it. Do not tell us anything in the chat about it.
Right.
Be fair. Be impartial. Just listen to what happens in the courtroom. Do not talk about it with anybody while you're moving through jury selection. Let's make sure we keep things pure and unadulterated in the courtroom.
Right.
Lucia, ridiculous every grand jury in Moscow would be overturned. Real speaks. I listed a sealed TV stand on eBay. Shortly after the TV stand company told me they would sue me if I didn't take it down. Could they actually do that? I don't know, Real speaks. I'd have to ask a lot more questions. John, do you think this is a clever move? Interesting to discuss. No, I don't find it clever. I don't love stuff like this to me. Again, I have to wonder if this case wasn't being so highly publicized, would they have filed this?
Probably not.
I would also wonder if I was another one of their clients in the public defender's office and I was charged by a grand jury indictment and it was the same as this and they didn't file this motion, I would have some questions. I would say, yo, Ann, Jay, what's up, man? Can't you file this for me too? If they think this is a legitimate argument. Starla, I'm headed out. Enjoy the reading, folks. Peter, thank you for your knowledge of the law. Just can't listen to 1800s law. Good night. See y'all tomorrow. See you, Starla. I understand. I do not blame you. All right, let's get back to it. The obvious and glaring error in this statement is that the court did not quote the standard required for finding an indictment. It quoted the statute defining the standard required for finding a presentment. Again, no further analysis was provided, but the court...
I think because he was bored of hearing this document. That's probably why he did it. That's great.
By the court as to why it would be quoting the standard used for a presentment when an indictment was at issue in the case. One possible explanation is that neither party brought to the court's attention that Idaho actually has two separate statutes defining the standards for indictments versus presentments, since the question that was not presented as an issue on appeal. So what I will say is they should look at this and they should make it more streamlined and make it uniform. Finally, the distinction was given or was again mentioned in State v. Edmondson. In Edmondson, the defendant challenged the grand jury indictment as a violation of the equal protection rights. The court quickly disposed of the argument by stating that Edmondson's failure to request a preliminary hearing is dispositive of this case. However, the court then continued by taking a more in-depth look at the equal protection argument. While doing so, the court made the following comment in dicta. By the way, if you're wondering what dicta is, it's basically discussion by the court. It is not a holding or a ruling or precedent that must be followed by lower courts.
Thank you,
it is
Michelle.
not the same thing as an actual decision made by the court. And it can be instructive in cases when you're making arguments. It can sometimes be persuasive, but it is not binding on other courts. And sometimes it's not even persuasive. The purpose of both grand jury proceedings and a preliminary hearing is to determine probable cause. No explanation or citation given for this statement. So again, this is not going their way. Several pages down in dicta, they said the purpose of the grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. Again, no explanation. Several pages later, the court briefly discusses the issue of prosecutorial misconduct. During this discussion, again in dicta, the court says, we note that the prosecutor directed the grand jury that it should not indict unless all elements for an alleged crime are proven beyond a reasonable doubt. This is a much higher standard than is required by Idaho law. Again, no explanation for or citation was given for this comment. One feasible explanation for why the court in Edmondson was of the belief that only probable cause was required for the finding of an indictment is that the time Edmondson was decided, Idaho had now adopted Criminal Rule 6, which provided that an indictment could be found if there was probable cause to believe that the accused had committed the crime. The court did not explicitly cite the rule, but the rule was in effect at the time of Edmondson.
Welcome, Jennifer, to the group.
Which I think means it's still in effect right now. Oh, here we go. So here's the next argument. The Idaho Supreme Court cannot adjust the standard of proof as it is a substantive right. So the next issue is going to be, we all agree at this point that the Idaho Supreme Court said it's probable cause for a grand jury indictment. Seems like everybody agrees. Seems like that's why they're saying that other court got it wrong.
A new member.
But they're saying the Idaho Supreme Court should have never been able to do that.
Oh.
It shouldn't have done it, period. AZ, If Judge cleans toilets for a living, he would be called John.
That's pretty good.
Thank you. It's exactly what we needed in the middle of this. Brooklyn Basement, what would you have done different in this motion? Honestly,
That's
Brooklyn,
AZ. That's one of my mods. That's great. That's really great. No, I didn't see that last night. That's good.
Basement, I can't answer
My
that because I don't
mod.
know what's in the grand jury documents, materials, proceedings,
I love it.
and transcripts. So I don't know if I would have found something different. I would not have made this argument personally. So if it works, kudos. Hats off to them if it works. New Chris is just checking in. Glad you're still here, New Chris. Not to be confused with old Chris. And thank you, Lisa. All right. Despite the fact that Idaho Code Section 191107 explicitly sets the standard of proof required for an indictment, approximately 100 years after Idaho codified the standard to be applied,
100 years
to be applied, our Supreme Court adopted ICR 6.5 that states that a grand jury ought to find an indictment when there is probable cause, which is basically how all of us thought it was happening, to believe the defendant committed the offense. It is therefore necessary to determine what standard governs the statute or the criminal rule. So here we go. Now begins this discussion. The court's rule-making power goes to procedural as opposed to substantive rules.
Thank you, Jennifer.
Thus, I'm literally having this argument. It's really funny. Tort reform is happening in Florida right now. We are literally litigating, fighting, having motions and hearings about the differences between procedural and substantive. Substantive are things that completely change the case. Prejudice, if something changes and you change the substantive law and apply it retroactively, can't happen. Procedural is just changing procedure. That can be applied retroactively. And like the way you have to file things, or you got to answer in 30 days or whatever it may be, versus the statute of limitations. That's substantive. Just to give you a quick example. This court's rulemaking power goes, I already read that. Thus, if the statute speaks towards a substantive right, it will prevail over a contrary criminal rule. But if the statute speaks only towards a procedural right, the criminal rule will prevail. Although a clear line of demarcation cannot always be delineated between what is substantive and what is procedural, the following general guidelines provide a useful framework for analysis. Substantive law prescribes norms for societal conduct and punishments for violations thereof. It thus creates, defines, and regulates primary rights. In contrast, practice and procedure pertain to essentially mechanical operations of the courts by which substantive law, rights, and remedies are effectuated. The standard of proof for finding an indictment is not a procedural right. Oh, it's not a procedural right, right? They're saying it's a substantive right. It does not deal with the manner of service or time for appearance, nor is it a matter of practice and procedure in all actions and proceedings. So I will also tell you, as we talk about this, it's always a gray area. There are always arguments on both sides when you start getting into whether or not something is substantive or procedural. The grand jury statute sets out the substantive rights of every citizen that must be followed before any citizen can be held to answer on a felony charge. This is a substantive right in that it grants every citizen of Idaho the right to not be held to answer on a felony charge unless the standard set out in Idaho Code Section 191102, 1007 has been met. Were this only a matter of procedure, every citizen of the state would be subject to detention to answer for a felony charge based upon the whims of the Supreme Court. Okay, so here's the other issue. He mentioned before that when things can be confusing or there are gray areas, the court steps in and can help define them. And they're putting this entire argument on the fact that this is clear. There's no reason to even discuss it. And because it's so clear that it's beyond a reasonable doubt, the fact that the court came in and completely changed that is so unfair. On the other side, if it was ambiguous and the court felt like they needed to make it more clear and they made this rule that said it's probable cause, it's probably probable cause. And that's, I think, where I land here. And they haven't really pulled me on their side very much at all. Standards of proof are considered substantive in every context, except apparently in dealing with conflicts of law. So even if it is a standard of proof is considered substantive, was there a clear set standard of proof based on the Fields law or whatever it is that we read that said it would warrant a conviction by a trial jury higher than probable cause? The Idaho Supreme Court has found it is a procedural issue and the standard of the forum state applies. So it sounds like they've already found that it's a procedural issue in dealing with conflicts of law. The United States Supreme Court, meanwhile, vehemently disagrees. In 1942, the court found the standard of proof is part of the substance of a claim and cannot be considered a mere indictment of a form of procedure. The court has followed that holding in various cases thereafter. So the Supreme Court says the standard of proof is part of the substance of a claim. Okay, that's important always. What the United States Supreme Court says is not just suggestive. It's not just something that is convincing, but it is, in fact, ruling law that you must follow.
Yeah.
However, we deal here with criminal law. Counsel can find no case that permits the courts to determine the standard in a criminal matter. Oh, so those were civil cases. Most recently, the United States Supreme Court considered standards regarding defenses in criminal action and never once indicated it was not for Congress to set the standard because it is a power belonging to the judiciary. So they're saying they confirmed that the court should not change the standard because they never once indicated that. It appears from the authorities that courts set the standard of proof by rule only in situations that are themselves creatures of procedure, like the standard to create a class in a class action, or the standard to show a past conviction is admissible under the evidentiary rules. If that were not enough, several important constitutional provisions should be kept in mind when considering whether the standard is substantive. First, our Constitution provides that all laws now enforced in the territory of Idaho shall remain in force until they be altered or repealed by the legislature. Second, the legislature shall pass all necessary laws to carry into effect the provisions of the Constitution. Finally, the right to have a grand jury make either a presentment or indictment finding prior to being held for trial is an Idaho constitutional right. And therefore, they're saying should be held by that standard, not the new criminal rule.
Hold at the top.
These provisions have important implications on this case. The section 1102 and 1107 were in force at the time our Constitution was adopted. They shall remain in force until they be altered by or repealed by the legislature, not simply until the judiciary decides to alter them, but until the legislature amends or repeals these statutes. This happens all the time where people feel like the courts are making law instead of interpreting it. That's part of the balance of powers. The legislature is supposed to make law or write law, and the judiciary is supposed to interpret it. Second, because the legislature was charged with passing all laws necessary to carry into effect the provisions of our Constitution, and because the right to a grand jury presentment or indictment is most certainly a constitutional right, it necessarily follows that it is the legislature who has authority to pass laws and will breathe life.
All right, I'm going to do this. I think the poll's going to win here. We're going to speed up and get to the questions, and then I'm going to wrap up this video. Let me see. He's going to take some questions here. He's just reading through the laws. I mean, it's a little snoozy right now. So we'll get to questions. I want to hear his questions.
Quash a warrant where the proceedings intrude on their constitutional rights. The court then found that a showing
90%.
that an instruction was prejudicial and it may require an indictment to be quashed. I think that's totally fair. And I think the court would make that decision. If in fact,
Let's
of course,
get to some questions.
That was the case. EDP is in the chat. What's up? I haven't been watching the chat as much because I'm reading. Whenever I'm reading, it's hard for me to follow the chat. And I was on my own until 5 seconds ago where John just jumped in and joined us. So normally the writing is concise. This is something. This is like their time to shine or something. I don't know what they're trying to do. I don't know.
Getting ridiculous.
Rob's brain hurts. My voice hurts. Sweet Tea needs a Tylenol. She's making sure I get a Tylenol. I'll be good. I read a lot for a living, but not so much out loud. Diana's thinking this motion to dismiss is going to get
denied.
I think I'm with you. Caitlin, in a day of unpredictability for me, tuning into your stream is such a relief and educational. Keep on keeping on. Caitlin, I'm glad you're here. And we've got just a few more pages to get through. John, isn't this the right move or only move by Ann Taylor to represent her client, even if it's a long shot? Thanks for your great input. So, John, here's what I'll say. I do think sometimes people take it a little too far to say, well, it's a defense attorney's right to zealously represent their client. That is true. I believe that with my whole heart. I think they should hold the state's feet to the fire. They should make sure everybody proves everything appropriately. They should make sure law enforcement does everything appropriately, that no corners were cut. But you do not have to try to make legal arguments that do not make sense. I don't know if I'll go as far as to say this one doesn't make sense. But I should not, because it may help my client. We just heard the congressional hearings on a UFO or whatever. I didn't watch it. I should not make the argument that aliens came and on that UFO, they took my client up there and therefore they're insane, so they're not guilty by reason of insanity. Or they dropped off an alien. That alien actually committed the crime. Could that help my client if I win? Sure. That doesn't mean I should do it. And I know that's not what you're saying, but sometimes I do think people take that a little far. You should not scream at the judge. You should not be disrespectful. Maybe that would help your client. Maybe the jury would like to see you be super aggressive. Sometimes people love aggressive lawyers, but you should not do that.
Hey, well,
Kiwi C, thanks for the super sticker. All right. So what prejudice results from telling a jury the wrong standard? Well, if they knew what a standard was and they could actually understand it, it's pretty obvious how that could prejudice the situation if you give them the wrong standard. I've had defense attorneys misstate or misexplain the standard of proof and jury selection. I object. We talk about it.
Thank
If
you,
there's a
Nikki.
disagreement, sometimes the judge will have to hop in and read what the
I'm going to get to some more questions.
what the
here.
actual standard is, what the actual burden is to the jury, just to make sure they're on the same page.
Let's go here. I'm going to bump up about 15 minutes.
All right, a presentment permits the
I
defendant
want to end this at about 15 minutes. So I want to do an hour and a half. So I skipped a little bit of it. I think we got the general idea of what this was, but I want to get to these questions.
Request a
before we wrap it
preliminary
up.
hearing. A magistrate is to proceed on a presentment as if it were an information. At first glance, this likely appears to undo much of what has come before. After all, if a presentment is an information, then it has already had a preliminary hearing. However, history being what it is, things are not so simple. Ain't that the truth? In 1887, when the revised statute were adopted, and information was the same as a complaint. So now they're saying, hey, Idaho, what you guys thought was an information is not actually an information. An information or a complaint is a paper charging a defendant with a particular offense, and it matters not what it is
1887.
called or whether it is called an information or a complaint. So basically, they used to be the same thing. I mean, charging document a lot of times is what you use because it can be a criminal complaint, it can be an information, it can be an indictment. Once arrested on an information, a defendant had a preliminary hearing referred to at that time as an examination. It was not until the code was revised, certainly not for the first time in 1969, that the terms became truly separate. Additionally, even in 1887, the word complaint was solely used in the code when discussing misdemeanors, while an information or complaint referred to a felony, at least in magistrate court. Some jurisdictions, that's still on point. New Chris. So basically, there's a chance he gets off.
No.
I don't think so. And even if they were to dismiss this complaint or quash this indictment, they would refile and they would do it again with a standard of beyond a reasonable doubt or a preliminary hearing or pick your poison. I think they win no matter which route they take.
Enough evidence.
J9 Wheels. Peter, if he had a solid alibi that made it difficult for the prosecution to even charge him, wouldn't he be free right now? Not necessarily. A lot of times defendants have pretty decent alibis or think they have strong alibis, and the state just doesn't believe it. They don't believe their cousin's friend's sister who said he was with me. They don't believe, whatever. They don't believe testimony. Usually if you have like video, filming you sleeping at 3 a.m. When they think you should have been out committing a crime, usually if you have something that rock solid, then yes, you would not be sitting in prison. Bryce, I think the state wanted to avoid the preliminary hearing. I mean, obviously they did. It was their choice, right? They chose to go the grand jury route, which was within their rights. LTL podcast, stalling. I don't really know if they're stalling, right? They got a 6-month window. They try to file a motion to stay. We'll see if the court grants it. They've already filed the motion, so let's have the hearing, right? Welcome, Michelle. All right. Thus, the question becomes, did the legislature change Chapter 5 and leave Chapter 12 alone to purposely turn a presentment into an indictment? The answer is clearly no.
He actually goes
Although
back
the purpose of the individual bill seems lost to
funny.
posterity,
You'll
the
hear him in a minute.
1966 court modernization
Like
plan and the
LTL
1969
podcast
court reforms are still extant. In 1966, the legislature wanted a modern court system. Part of that plan was to do away with the justice of the peace, police courts, and probate courts, and have a 2-tier trial court system. According to the Committee on Court Study, the intention was district courts and magistrates. The third major area of concern of the Committee on Courts and the Advisory Committee was to provide for a 2-level system of courts in Idaho. This is the heart of the preliminary report. It encompasses proposals that some may consider a radical break with tradition. However, the Committee on Courts and the Advisory Committee feel that this is a logical step that must be taken to put into effect the clearly expressed wishes of Idaho voters when they adopted the constitutional amendment in 1962 to provide for a unified and integrated judicial system. The proposals contained in this section of the preliminary reports have been prepared in separate sections for easier study. This section includes proposals to abolish the present probate, justice of the peace and police courts, to create a system of district court magistrates appointed by district judges, to define more clearly the duties and authority in the administrative matters of the senior district judge, to reenact provisions for a small claims department of the magistrates division, and to change the method of paying for the costs of jury trials in the district court from the county to the state. The plan never mentions the intention to make it clear that complaints and informations are separate, but it does mention that the Colorado system does so. Okay? So by not saying it and they saying that Colorado did, that means we didn't want to do it here. In 1969, much of the court reform recommended was made into law. although the purpose of Bill 79 is not in the session laws. Its title in the index is Complaint, Definition, Contents,
I'd rather have
Transmissions,
Peter
Delivery,
on the channel.
as well as
I'm
complaint,
working on it.
examination of person, lodging. Additionally, the legislature amended much of Chapter 8 to create the modern preliminary hearing, replete with new references to the complaint. No laws were passed.
Thing about shorts is like I don't have time to do it. That's the problem. Like that's why I don't have time because I work. So I work like 50 hours a week. I work from 10 a.m. to almost 8 o'clock every night. And then I'm up at 6. And then from 6, like 6:30 to 7:30, I'm at the gym. And then I come home and I literally have an hour to get ready to go to work. And within that hour, I'm literally lining up all my presentations, getting the thumbnail made, getting my live stream put together so I can just come home, turn the computer on and do a live stream. So I don't have time to do shorts. And I'll be honest with you, I've done shorts in the past and they just don't do well on my channel. I get like 1 view on them. So to go through all that is tough. It's too time consuming for me. So it's just easier for me to live stream, download it, and re-upload it like a day later for a couple extra hits. But I do know this on Sunday, all day on Sunday, I'm going to take the Coffin Daffer interview and cut it all up into a bunch of clips and release all that. Maybe I'll do some shorts out of it and try that. But shorts just have never done well on my channel. I'm just not a shorts channel. The problem is that, you know, Tanya and I, our channels, the way that the YouTube algorithm looks at us is we're long form content, and everybody out there just wants those short blasts now. And she can probably attest to this too. And I know I'm going off on a tangent about YouTube right now. If I do an 8-minute video, people are only going to watch half of it. If I do an hour-long stream, I'm lucky if I get a watch time over a half an hour on a replay. It's crazy, the attention spans. People cannot sit and watch like a whole episode. Tanya probably can contest to this too. You know, she works really hard on videos, and it's disheartening sometimes because you'll do an 8-minute video, a 9-minute video, which is like the standard on YouTube. You put it out and you get like 200 hits on it. It's very disheartening. You've worked maybe 2-3 hours to put that together. I hate shorts too. I absolutely hate shorts. It ruined this platform 100% for sure. It ruined this platform because we've now shrank everybody's attention span down to 30 seconds. So they won't sit through a live show. Live shows like 5 years ago were fucking huge. You could get 600, 700, 800, 900 people a night watching. Now no one will watch. Everybody will just watch on replay and pick and choose what they want to watch during that stream. I know I'm going off on like a YouTube tangent right now. I was going to say something else too, but I forgot. But anyway, let's try to get through the rest of this video and then wrap it up. If it comes to my mind, I'll stop.
Affecting functioning of the grand jury. Since 1969, the legislature made various adjustments to the criminal procedure. However, not one law pertaining to a presentment has been passed since 1919. Probably because they don't use presentments anymore, right? It makes no sense. For these reasons, it is clear that
this is what I was going to say. So it's harder for like, I think the biggest thing that's stifling my channel right now is that all my stuff is long form. So it's over an hour and a half. And what the algorithm does is it looks for people that want that type of content. And not a lot of people today want that type of content. That's why my subscriber growth is really slow, because it's got to align. It's got to find people that like true crime, that want to sit through an hour and a half show, or come to a live stream or watch a replay that's an hour and a half. So I have kind of at a disadvantage where I can't cut things down to 8 minutes. I can't do an 8-minute live show. It'd be ridiculous. Okay, here's the news. This is what we're gonna do. See you later. Right? You know, it wouldn't work. So it's tough. This is tough to get a lot of subscribers on long form channels. It's just the grind. I mean, I have almost 500 videos on my channel.
It is clear again. I love when lawyers say that.
Anyway,
Idaho Code Section 19-1207 still intends for a presentment to be treated as we would now treat a complaint containing a felony. Thus, if the court sees fit, it could simply remand the matter to the magistrate for the necessary preliminary hearing rather than going through a dismissal and having to determine whether the matter may be resubmitted to the grand jury. Now, doing
algorithm
something
sucks.
like that would reset the speedy trial
I'm
clock.
curious if Tanya's in the chat. Tanya, did you get a survey today about YouTube, how they pay people? I actually responded to it this morning. I was curious to see if you got that survey as well too.
And
Like
that would
how
give
they
them more
do their
time,
payment.
as LTL podcast said.
Oh, there it was.
So
Let's go
what they're
back a
trying to
little
do is Idaho Code Section 19-1207 still intends for a presentment to be treated as we would now treat a complaint containing a felony. Thus, if the court sees fit, it could simply remand the matter to the magistrate for the necessary preliminary hearing rather than going through a dismissal and having to determine whether the matter may be resubmitted to the grand jury. Now, doing something like that would reset the speedy trial clock, and that would give them more time, as LTL podcast said.
Whoa, look at that.
So
Mr. Tragos,
what they're trying to do
thank
is
you very much, sir.
quash
Appreciate
this
you.
indictment. If they can't
Appreciate
quash
you.
it, they want it
Now
to be called
you
a
need to come over
presentment.
here and come.
And
let
they're
me
saying that
interview you.
because the standard probable cause is more in line with a presentment versus what they think should be beyond a reasonable doubt for an indictment. So therefore, indictment out because they didn't say the right burden of proof.
All right, we're gonna.
If presentment is in, then that would mean if we're going under all this crazy old law,
Copyright.
we would come back in and now it would go to a preliminary hearing if the defendant says so or demands it in front of a magistrate, which it seems like the defendant wants. Why would they want a preliminary hearing? We talked about a lot of this. They can get some information. They can take some cracks at some witnesses. They can see how the state presents their case. They can hear some arguments potentially. They just get some free information. And again, it would extend the clock and allow them to prepare more for the case.
Stuff.
Alibi, this is so much to comprehend, but so happy to be here, and thank you for covering this for us all. Obviously, I can't dig into and hit every point. I'm sure other lawyers like Emily and maybe Rob will be looking into this as well. I'm sure they'll hit different points, pull different things out of it. That's what makes this so great, right? That's what makes this whole thing called YouTube so great. Katie, okay, is this confusing for the lawyers here too? Yes. Yes.
I love that.
Pan Tuffle, can you just tell us what you drink from the cup? From this cup, it's just water. Just water for me.
All right, I'm going to end this because I do want to end on an hour and a half. I'm getting a little tired here, and I have a small day at work tomorrow from 10 to 2, and then I need to come home and prepare for tomorrow night's show. But what I want to do is rock out to some 1887 fife music. But like we always do, we want to end on a positive note. I've always tried to do that with my shows, ending on a positive note. And what I want to do first, before I do that, was my fife music again. Before I do that, I want to just show you. I did a poll on my community page today, and I came up with, do you think Brian Kohberger's indictment will be overturned? 15% said yes, and 85% said no. And we had over 218 votes. So, what I want to do is before I end the stream, yeah, I know I gotta make a soundbite of that song. If I'm probably gonna get nailed for. So tomorrow night at 9:15, Tanya and I, after we do her show, are gonna come over and do a show over here. If she ends a little bit earlier or whatever, maybe we'll start a little bit earlier. I don't know how long she has her show planned for, but I'm sure we'll get probably like a 5 or 10 minute break in between shows. But there's the link for tomorrow night's show. You're going to want to set your reminder. We're going to do a double dual stream tomorrow night, 2-for-1 combo meal deal. I think it's going to be a really great time. I actually want to get over on her panel. I think I've only been over there once, and I want to go chill, actually twice, because I did a members thing with her the other day, but I want to get over there and chill with her over there. But what I want to do is I've been trying to do this theme at the end of shows, ending on a positive note. And what I want to do this evening is play a little bit of a tribute here to my buddy, my YouTube buddy, my friend that I've gotten to really know over the last couple of months here, and just say that I'm extremely proud of Tanya for reaching the 10,000 subscriber mark on her channel. She's been well-deserved to do that and has worked extremely hard. She is someone that I'm going to get probably a little emotional here. She is someone that has been through a lot in her life and has persevered and come back. And I consider her a real a real friend of this channel, and has been a real friend to me. And she really helped me the other day. Her and Laura really helped me the other day with Jennifer Coffindaffer, because I literally, I did not think it was going to happen. And it popped up very spontaneously after some kind of dead communication with Jennifer. And she literally flipped the time at me really quick and said, I have 5 p.m. Eastern Standard Time today. One really great thing about it is that I was home from work, so I had the opportunity to do the interview. And I always feel that things happen for an absolute reason in life. And I really love doing this. I really feel like this is my calling, and I really want this to be, you know, my job someday, to be a credible, I guess, YouTube journalist, if you want to call it that, or just have a credible podcast channel. And I feel like, you know, getting Jennifer on the channel kind of nailed down some of that credibility. I was so happy with that interview. It just couldn't have been any better. There was a little bit of a stumble in the beginning. I think I got a little nervous, and I had a bunch of tabs open and everything was like playing at once, but I recovered really well. And then Jennifer had a little bit of a Wi-Fi issue and she recovered really well. But I don't want to talk about that, but I want to get back to Tanya. Again, she's really persevered through a lot of things in her life. And she's, you know, definitely someone that needs to be here with our, you know, in our time and space. And that's why she's here with us. So I want to celebrate Tanya this evening. Titanium Built channel. If you haven't gone over and you're watching the stream right now, go over and subscribe to her channel. And then let's come back here and get Let's Talk Live podcast to 10,000 subscribers so we can celebrate together. So I'm extremely proud of her. I've getting to know her over these last couple of months and weeks, and just really enjoy hanging out with her. And she's going to thrive on this space. I really do believe that. Yeah, I just want to do this for her tonight. So that's going to be it. We're going to wrap up the show. It's 11:08 here, Eastern Standard Time on the East Coast. We're going to end this tonight. I want to thank everybody here in this chat for hanging out this evening. You all are really great. You all make this channel go, and we can't do this without you. So tomorrow night I'll be hanging out with Tanya. She'll hit me up with the link probably tonight or tomorrow, and I'll join her over there. I got to come back when I get off work tomorrow, prepare for my show. I don't know. Maybe we'll just do an open discussion and say, just have fun, let loose a little bit. Not really anything too serious. We'll take some calls. We'll hang out, kind of the after show after Tanya does hers, and I'm going to go over and support her on her channel. So, things work together. You know, when you work together, the community thrives more. You know, I just wish some of these other bigger creators would open up their platforms a little bit more, give us, you know, us smaller channels some exposure, because I think we're doing really great things over here. I really do. And, you know, it was just so nice to see Jennifer's response to that interview, and, you know, having her post that on her Twitter, and it got a little bit of reach. And, you know, it's the video is growing. My goal is to get at least 10,000 votes on views on that video. So I'm going to leave it up on the main page for a little while, and you know, we'll go on to the next interview. I'm going to try to get Peter. I'm working on it, but I'm going to try to get him over here. I know you all want to see him over here, and I will try to accomplish that. So tomorrow night, come hang out. I'm going to drop the link again. Save your reminder. We'll be back here 9-ish, 9:15-ish tomorrow night. Everybody be safe, be kind. You know how to do it. Come back, watch LTL podcast tomorrow night. We really would appreciate it. My long-winded goodbye. All right. Have a good night. I'll talk to you all soon. Bye.